Hey, Professor Fields here. AJ 100 Introduction to AJ. This is Chapter 7. We're talking about the courts and the judiciary. So, this is learning outcome number 1, module learning outcome number 1, which is identify the basic federal and state court structures and their jurisdictions. So, to start with, we've got a dual court system. We have a separate federal and state court systems, and they have different issues they have to deal with. Basically, the federal court deals with only constitutional issues or issues of great significance to the United States. And the state Supreme Court deals with each state's issues, mainly constitutional issues and other issues within the state itself. And I'll explain that more in depth as we get to the further slides. So 1789, they established a federal judiciary. Here's a quick diagram of it, and we'll go through each of these sections here: the district courts, the circuit courts, the federal courts. That was the federal court system. The highest court in the land is the United States Supreme Court. There's one Chief Justice and 8 Associate Justices. They have an odd number, so there's never a split. Well, there's a split decision, but it's never even. How do you get to be a Supreme Court Justice? You get nominated by the President and approved by Congress, and it's a lifetime appointment. You're there until you either retire or expire. Just below them is the Court of Appeals, and they have 12 regional courts, circuit courts. California is in the 9th Court of Appeals. And those courts of appeals mainly hear criminal and prisoner petitions and administrative decisions on administrative issues surrounding the state. I'll give you an example. The state of California had, you may be familiar with AB 109, and that was a mandate that the state prisons be reduced in population because the inmates weren't getting their rights. That was the result of a ruling by the circuit court that said, hey, we need to reduce the prison population so they can get medical care. Now, Federal Court of Appeals, they hear patent cases. They hear, it's a separate court than the rest of the courts. There's only one of them, the Federal Court of Appeals. And they hear courts of trade infringement, international companies like Apple, stuff like that. If there's a copyright infringement, a lot of what they call pirated DVDs, like movies and stuff, come out of places like China, and if Sony Pictures, say, wants to sue, they can sue in the federal court for that. They also have jurisdiction over criminal cases. Excuse me. There's 94 judicial districts in the district courts. Now, the district court is similar to, and we'll talk about it in a few minutes, to the Superior Court in California, except that they only hear the federal matters. If we go back a couple of chapters, we talked about jurisdiction, where if you're drunk driving in the state of California, a California police officer like the Highway Patrol or LAPD can arrest you for drunk driving. However, a federal agent does not have jurisdiction because it's not a federal offense to drive drunk. Other way around, immigration. Immigration is a federal offense. State and local cannot arrest you for the federal offense. They can detain you and turn you over to the federal authorities if they want to take you, but you can't be arrested for an on-view charge of being illegally in this country. So that's the role of the federal courts. And their jurisdiction, like I said, is federal crimes and federal properties also. So if you're in a federal park or a national park like Yosemite and commit a crime, you got to go to federal court in San Francisco to hear the case. The courts have a thing called judicial review, which means that in addition to all the other duties, and we'll talk about the trial in 2 chapters from now, but for right now we're just talking about the basic structure. And basically what judicial review means is they can review the decisions of the lower courts and decide on the constitutionality of the law, if there's something wrong. And we have the 3 branches of government. You have the legislative branch who makes the laws, the presidential branch that enforces the laws, and the judicial branch, which decides on whether or not the law is constitutional, is legal. And the reason we have those three is so that we can separate the powers, and so no one person has absolute power. And we'll talk about the appointment of judges. It's supposed to be that judges are appointed without political influence, but we'll talk about that. That's not truly the case. The judges rely on the Constitution to set the standards. Some judges rule on a strict interpretation of the Constitution, and others interpret the document within the context of what's going on in society and what's hip today and what the way society is thinking today. And we'll go over that concept in the next few slides. Judicial activism is what is called, and it allows for the judges to basically interpret the way they see the Constitution. Here's a quick example. Plessy versus Ferguson, 1896. Slavery had been ended by the 13th Amendment, but there were still facilities that if you were at a restroom back in the South, especially during that time, there was a bathroom that said colored and a bathroom that said white, and it was against the law for a black person to go into a white bathroom. And so you could be arrested for that. And so Plessy sued, and the court said, you know what, separate but equal facilities for blacks and whites does not violate the 14th Amendment, the due process and equal protection clauses of the 14th Amendment. However, later on, 1954, and if you go back to our earlier discussions in Chapter 5, we talked about the progression of police work over the centuries, over the decades, sorry. Go back to 1954, the civil rights movement is starting to gain some steam there, heading into the 60s. The Supreme Court overturned Plessy in the case of Brown versus Board of Education, and basically what it said was that separate but equal is not. It is a violation of the 14th Amendment. It does not give due process and equal treatment. It's still at work today. Here's a couple of recent cases. The same-sex marriage was a case that went before the Supreme Court. They decided, again, the 14th Amendment applied there, that people weren't treated equally. They ruled on Affordable Care Act. There's no constitutional issue there, but there's an issue of significant social impact, is why they ruled on that. And abortion is one that keeps going back and forth. Roe versus Wade is the big case in that, but there's been other cases that have heard and redefined what's legal and what's not legal when it comes to abortion. Now, jurisdiction talks about the court's authority to hear certain types of cases. In other words, if you got arrested for DUI in Torrance, they're not going to take you to the federal court because the federal court has no jurisdiction there unless there's a constitutional matter, and we'll talk about that on the appeals. Here's a quick diagram of how the courts work. This comes straight out of the textbook. So let's give you an example of how the judicial review works. Sorry about the spelling error there. Should probably fix that. Proposition 8 passes a state law in California, and basically what it said was that same-sex marriage was illegal. So the state of California passed a law that said same-sex marriage was illegal. It was appealed by people who wanted to be married to the California Supreme Court, and the Supreme Court said, yep, it's legal. The law was legal. In other words, we can ban same-sex marriage because that's the community standard. And go back to chapters 1 and 2 in the text. We talked about how community standards a lot of times set what goes on in each community and the separation between the state governments and the federal governments. So then it was appealed to the U.S. District Court, Northern California, again on the United States Constitution. The earlier appeal to the California Supreme Court was on the state's Constitution. Now this one was an appeal on the 14th Amendment to the United States Constitution, and they found, in fact, that the law was illegal. So they repealed the law, or they put the law on hold, saying it was illegal, because immediately the people that wanted to ban same-sex marriage appealed it to the United States Supreme Court. Here's where it gets kind of interesting. The group appealed it to the United States Supreme Court, but they were not denied on the issues of the case. They were denied because they didn't have standing in the case. In other words, they weren't a party. Give you an example. Say you get in a car wreck. I don't know you, whoever's listening to this, gets in a car wreck with somebody else. I can't sue that other person because I'm not part of this issue. So that's what the Supreme Court said, was that the person appealing was not the right person. The person that should appeal the state law would have been the California Attorney General, Kamala Harris at the time, and she's still our Attorney State General. Basically, she refused to do her job and defend the decisions of the people of the state of California, and she justified her defense based on moral grounds. And we talked about this 2 chapters ago, and we talked about, as a law enforcement officer, would you be willing to enforce a law that you morally did not agree with, and what would be the consequences? Now, we kind of decided as a law enforcement officer, you're probably going to get in some kind of trouble. Kamala Harris is answerable to the electorate, and so they could decide to either recall her or not re-elect her. She happens to be a very popular Attorney General, so chances of that happening right now are slim to none. So she was able to do that, you know. And we talked about the Jim Crow laws. Remember earlier I said the colored versus white. Would you be willing, as a police officer, to enforce a law that you felt was illegal? And general consensus is you should, because you take an oath to uphold the Constitution and the laws of the state of California. So that was the federal court system. Let's talk about the state court systems. They pretty much mirror the federal court systems. Things start at the beginning, which is the Superior Court. And we'll talk about Superior Courts in a minute in California. And then if the appeal goes down, it goes up to the Courts of Appeal, then the California Supreme Court. California trial courts are called Superior Courts. We used to have, quite a while ago, we had municipal courts and justice courts, but they eliminated all those, and now they just have a Superior Court. Each county has a Superior Court. There's 58 counties. And each of those Superior Courts in most counties, some counties are very small, but a county like Los Angeles has multiple branches. For instance, around our campus here, El Camino campus, we have Torrance and Compton courts. As a matter of fact, we have staff. We have judges that teach criminal law at our institution that are judges in those courts. So let's recap. We went over the basic structure of the California courts, California State Court and the federal courts. In the next learning objectives, in the next learning objectives we'll discuss how the appeal process works, how a case gets to the Supreme Court, and other issues like that. Thank you.